The New Delhi Principal Bench of the Custom Excise and Service Tax Appellate Tribunal has upheld excise duty evasion charges citing clandestine manufacture and clearance of pan masala and gutka under well-known brand names without payment of central excise duty. The appellants were found engaged in unregistered manufacture and sale of pan masala, gutka, and chewing tobacco of brands such as RMD, Vimal, Rajnigandha, and Tulsi from multiple unlicensed premises in Indore. Acting on intelligence, the Central Excise Department conducted simultaneously searches at 5 locations on 13th July 2015, seizing goods, machinery, and 6.76 lakh in cash. The total value of seized goods was 25.85 lakhs. Statements recorded during the operation confirmed that no stock registers were maintained and goods were sold without bills. So, a show cause notice was issued proposing confiscation of goods under Rule 25 of Central Excise Rules 2002 and cash under Section 121 of the Customs Act 1962. The order in original passed on 31st May 2019 confirmed the duly demand confiscation of goods and penalties. Redemption fine was offered for the release of machinery. The appellants filed appeal before CESTAT but failed to pursue them diligently. Despite multiple opportunities, they did not cure procedural defects, submitted written arguments, or appear during the final hearing. The tribunal observed that their conduct amounted to deliberate delay and obstruction of adjudication process. During the hearing, Revenue Council argued that appellants were engaged in manufacturing excisable goods without registration of invoices and that the seized cash represented sale proceeds of these unaccounted clearances. They further submitted that statements from appellants and third parties, as well as documentary evidences and material recovered, clearly established the charge and excise evasion. CESTAT found that the appellants had admitted to manufacturing and selling pan masala and gutka without proper authorization or invoices. They could not produce any permission from brand owners for manufacturing goods in their names. The tribunal observed that admission made in statements require no further proof and the evidence on record was sufficient to uphold the charges. Relying on the Supreme Court's direction in Jai Balaji Industries versus D.K. Mohanty, the tribunal held that there was no justification to disturb the findings of the adjudicating authority. The appeals were dismissed and the original order confirming the excise duty evasion, confiscation and penalties was upheld. This was done in the case of Shri Sandeep Mata versus Commissioner of CGST and Central Excise, Indore. Excise Appeal number 51771 of 2022.